there are a lot of times people will put things in and it's very heartfelt and it's an emotional situation. And it starts to sound more like a journal entry or a diary entry or a love letter, not a legal document. But they're not grasping the concept of and the result of the language they're using. In general, they're guaranteed to work in whatever state you're in. But if there's a problem, if you read the fine print, all they'll do is give you your money back. Well, at that point, you've either already died, you're too far gone to redraft documents. And oftentimes, in my opinion, you're better off just not even having a document than dealing with an online form you just buy and fill in yourself. Because there's a lot of a domino effect that it's hard to explain that could come into play based on what you've done. Kind of that phrase, you can't unring a bell, especially when dealing with real estate. If you file a deed thinking you just pulled it online, and especially people like to use quick claim deeds because it looks so simple, there's major tax consequences that can have a domino effect with that we can't undo because you've already created that transaction. In general, and this will kind of be our highlight for our conversation tonight, it's about access and it's about authority. It's really, those are the two words I'll use over and over again, is access and authority. Most people think when they go to estate planning, it's straight to what happens when I die. There's a lot that's going to happen beforehand, and especially with the medical matters that you all are dealing with, healthcare surrogates, HIPAA release, financial, insurance. Honestly, after someone passes, except for minor children, it's just stuff. It's money, it's stuff. I don't mean to simplify it that much, but it really is, except for minor children. Before you die, your care, the access and authority to take care of you when you can't take care of yourself, in my opinion, is even more important, because that's quality of life. That's being able to get you the care you need, have the money to support it, get to the insurance, all of those things. So don't take that part for granted. One thing you absolutely have to have, this is federal, is somebody who has the ability to talk to your doctors, even as husband and wife or adult children. Federal law restricts access to medical records, and you've all heard of HIPAA. Yes, you can go to your primary care doctor and sign their form, but that's for that office. When you go to a specialist office or you go to a hospital, everyone's got their own forms. Through estate planning with your state laws, you can set up a proxy or a healthcare surrogate as to who that person will be, and giving them authority to talk to your doctors and letting the doctors share that medical records and information. That's extremely important. Again, that's the access to your records and the authority to talk to the doctors. I'm sure, as I hear over and over, but I know my daughter will be there for me. Yes, absolutely, she'll be there, but give her the authority and the access to do what's needed. That's really what estate planning is all about, is giving somebody the authority and the access. We really are getting further and further away from a family unit to being individuals. Even spouses, children, and adults, as you all probably know, people who have completely separate finances within a marriage. There's a lot of separation now, so there's no assumption that just because this is your daughter, your mother, your father, your spouse, that they will have access unless you say and put in writing that person has access and authority.
So the healthcare surrogate, is that a person who's making decisions on your behalf or simply having access to your medical records?
Primarily making decisions on your behalf, but if they don't have the access, it's going to be really hard to make the decisions. So in an emergency situation, states will often have a default of a proxy, like your spouse, to make decisions, your next of kin, but that doesn't give them access to your records. So, emergency room, department, you're brought in by an ambulance, got to make those immediate decisions. Yes, you probably can make those decisions depending on your state law. What I'm more concerned about is the rehab after, the coordinating with specialists, the whatever facility you need to go to. It's that aftercare, that coordination, that even though this is your person, they may not have the ability to pull together all that information. And I'm sure you all, even more so than I understand, coordinating specialists is a complete nightmare. So if you can't even talk to them, that's going to make that process even harder. So giving somebody the authority and the access, authority to talk to them and the access to get the records is very important.
Because most of the forms that you would see, say at a hospital, I think we were talking earlier, when I've had surgeries, they're always like, here, sign this form. Who do you want access? That sort of thing. But all of that expires, right?
The moment you leave the hospital, it's only good for that one admission or that one procedure.
I remember when I was going through my own surgery also, I had to assign who that proxy was. And it was actually kind of a contentious moment of, is it my spouse? Is it my partner? Is it my family? Is it my sibling? Like trying to navigate that dynamic in and of itself, where you're managing a cancer diagnosis in your own surgery, let alone the family dynamics of who's going to be signing these papers and who you want to allow to have access.
And that same thought, Laura, you've got so many other things going on to then have to navigate everyone else's feelings should not be something you're concerned about at that point. You know, you love your family and they're all there for you, but you shouldn't have to navigate all those at that point. And I get asked a lot, who should be your healthcare surrogate? I mean, typically default, it's your spouse. If not your spouse, your adult children. But I often have clients that come in and they choose to override that. And you can't. They say, listen, I adore my spouse or I adore my mother or whoever it is, but they're not going to be good in this situation. They will not handle the stress of the situation well. And that's okay, because you have to look at someone who is able to be level-headed, who can take in all the information. They don't have to be a medical professional. They don't have to be a nurse or a doctor or anything, but can take in the information and gather that information, share it with the family if you want them to make those decisions, but be able to manage that process. And sometimes your next of kin is not someone who can do that. You know, I say, if you're laying on that gurney in the hospital bed and you can't speak and you know they're talking about you, who do you want talking? Who is that person going to be? And at that point, you cannot think about hurting mom's feelings or your husband's feelings or your wife's feelings. It's got to be who is going to be calm in that moment and be able to intake that information. Because when we're stressed, we tend to, our brain can't process everything that's coming at us. And you've got to have someone that can process that information. So
for a healthcare surrogate, you know, obviously picking temperament and that sort of thing, usually they've got to be an adult though, right? It can't be a minor.
Absolutely, over 18.
Okay.
You know, I'm not a huge fan of someone in their 20s. There's a lot of development still going on there, but over 18 is the law. Someone that's a little more mature than their 20s typically, but sometimes that is the best person. You have to make those decisions. Definitely, without a doubt, over 18. Mm-hmm.
And for a healthcare surrogate document, that document's not going to say you're allowed to share this information with mom, but not dad. Would that be a separate conversation in terms of how you would want the information to flow?
Well, all you're listing on that document is who the doctor may provide that information to. Unfortunately, if you do have person A listed and person A decides to take it all and share with person B, that's beyond the doctor's authority to manage that, you know. So that's difficult. You have to trust that individual with the information they're going to have. You know, you have to realize yourself how sensitive you are to your privacy in that situation and how sensitive they will be to keeping that privacy. So the document will say, doctor, you may share with person A, but what person A does with that is going to be a little beyond the control of the document. If you're going to put two people, you've got to make sure that they can work together. But yes, you can do primaries and alternates for healthcare decision making.
All right, so healthcare surrogate is one of those documents that you need before death, right? Something that it's kind of a living, breathing document to a certain extent. How do you change it?
You can amend it. It really goes to how much you've shared it. So if you've told person A, hey, you're my person, and if something happens and then later you choose to change that, they have to be notified that you've revoked those privileges. And that is done in writing, and you have to tell them. So it is a difficult conversation. It doesn't mean it can't happen, but you have to be aware of how far you've spread that information. Personally, I believe to share expectations and why you've made the decision you've made. And you need to know that that's for your best interest, even if it's not what everyone else would have chosen. You have to make what's your decision for your care and what you need.
Does that document stay unless you change it? It's good forever. There's no expiration.
I can't speak for every state, but in Florida, that is true. That document is good until you revoke it, and can continue on. There's a phrase called durable that you'll see often in estate planning. That means it withstands your incompetency. In other words, that person continues to have authority even if you're incapacitated. And that's when you really need the documents. That's when you need that person to step in. So keep in mind, what we're discussing right now is your care while you're alive. We will get to the after death part. We're talking about taking care of you, the person, right now, if you can't take care of yourself.
So what happens if you're in the hospital and you create one of these healthcare surrogates or a power of attorney or some legal document that gives power to a person, but your estate planning documents that are at home say somebody else? Who wins?
The hospital is going to honor the document, the form you signed at their hospital, because in short, their attorneys have drafted it. They like the language.
So what if the person who had the previous power of attorney or healthcare surrogate document comes in, hey, I have this? Then
If
what?
it has a HIPAA release, they still have access to your records. And if there is a dispute between them and the hospital feels necessary, they will take it to a judge and ask the judge to decide. But the hospital will certainly honor their own form. It will not be nullified because you had an outside document. And if you're planning to make a permanent change, signing the hospital form is not going to accomplish that. You're going to have to go through the process of voiding your previous document and letting them know that you've made other decisions.
And really, in that scenario, all that ends up happening is your care gets delayed, right? While they figure out what to do. And so, but they would still act if it was an emergency because they're required to, right?
Yeah.
Okay.